All right, Luke, and I can take it over from here?
Yep, absolutely.
Thank you very much, and thank you all for participating today. I apologize for those introductory remarks. We had to set it up a bit different today, so I wanted to make sure that everybody could hear me. My name is Kim Stenger. I'm the head of our firm's Health Law Group, and welcome to 2017. I think this is the first of our webinar series for 2017. Today we're going to be talking about fraud and abuse laws and how to live with those in the modern era. A few preliminaries. This is going to be an overview of some of the relevant federal laws. We're not going to be able to go through all of them that may be out there that may affect you, but we wanted to touch on the big ones, the things like the Anti-kickback Statute, False Claims Act, Stark, and the Civil Monetary Penalties Law. Just remember that additional laws may apply to you. Particularly, each state has its own fraud and abuse laws. I'll talk briefly about those, but you need to be aware of what's going on in your particular state. There could be other federal laws that may apply to you depending upon the type of provider or supplier or entity that you are. Also, don't forget about your payer contracts. Sometimes your payer contracts have additional terms in them. For example, they might prohibit you from waiving or discounting co-pays and deductibles if you fail to comply with those. Even if Stark and the Anti-kickback Statute might not apply, then you could be liable potentially for breach of contract, or even, there are some lawsuits out there, for healthcare fraud. When it comes to applying these, make sure that you look at the particular circumstances and the statute when it comes to applying it. And we're going to be moving pretty fast going through this stuff. We have provided you with some written materials, including an article that I've done that talks about overview of these laws and their application to healthcare transactions. I've given you some information from the OIG, particularly if you are a hospital or a physician that deals with hospitals. You'd have to look at the OIG Supplemental Compliance Program guidance for hospitals. It really goes through these rules and regulations in a helpful way, and that's one of the best resources for you. This program is being recorded and will be available for future use if you should want to use it. One of the reasons for doing these programs is to provide you a way that you could provide training for your staff on these issues. It's always helpful as part of your compliance program to provide ongoing training. So we have recorded these so that you could use them in the future should you want to do so. If you have questions throughout the program, you can submit them using the chat feature. I think that I can see them, or alternatively, you can just shoot me an email offline and I'll respond offline. With that said, let's talk about fraud and abuse. Not surprisingly, the government's concerned about its diminishing Medicare, Medicaid funds, and therefore it is actively out there trying to recover those funds. To date, the government has recovered about $30 billion since 2009. In 2016 alone, I looked at a DOJ report. They recovered $2.5 billion just on the False Claims Act in 2016. We've got a new administration coming in. Do we think it'll be different under the Trump administration? I don't think so. Trump, in his public statements, has indicated that he thinks that there's a lot of fraud and abuse, a lot of waste out there, and so I would expect that those government enforcement actions will continue going forward. The government actually makes money on these, if you want to look at it this way. According to a 2015 study, for every dollar that the government spends in enforcement, the government recovers $7.70. So that was back in 2015. I think that given the increased enforcement since then, I think that number is probably actually increased. So the bottom line is you're going to have to deal with this going forward. Just look at some of the recent cases and you can see how those penalties can come back and haunt you. A lot of the recent cases in hundreds of millions of dollars, or at least tens of millions of dollars. Now, if that's not enough to get your attention, hopefully you're aware of the Yates memo, because if not, and you are a C-suite person at your organization or are dealing with fraud and abuse issues on a regular basis, you need to be aware of the Yates memo. In September 2015, the DOJ Deputy AG Sally Yates released a memo that basically says, hey, going forward, we want to make sure that if we're going to go after somebody for fraud and abuse, False Claims Act violations or the like, we're not just going to look at corporate wrongdoing, we're going to look at individual wrongdoing. They concluded that simply imposing fines and penalties against the corporations was not deterring fraud and abuse sufficiently, and therefore they're going to take it to the individual. Among other things, if the company is going to self-report to get the benefit of a self-report, part of the information they're going to have to disclose is information concerning concerned individuals. So they're going to have to give names of people who were involved in the transactions. The government will then use that information to look at the individual liability of those who were involved in the transaction. Case in point, I'll talk a little bit later about the Twomey case out of South Carolina, but the chief executive officer for the hospital that was involved in that particular transaction recently agreed to pay $1 million because of his involvement in the transaction. He's not the only one that's out there. So you, as healthcare providers, as administration, you need to be concerned about personal liability as you move forward. So you need to take the compliance issues very seriously. Now, if that's not enough to get your attention, hopefully this will also, of course, under the Affordable Care Act, you now have an affirmative obligation to narc on yourself, meaning that you have an obligation to report and repay money to the federal government if you have received payments in violation of these federal fraud and abuse laws. With that, by way of introduction, let's talk about the laws. First and foremost, the False Claims Act. This is really the workhorse for the government in pursuing claims against providers to get repayment. The False Claims Act says you cannot knowingly submit a false claim for payment to the federal government, and in the wake of the Affordable Care Act, you must report and repay an overpayment within 60 days or the date a cost report is due. So if you've received money improperly, even though you didn't do it intentionally false, if you received money that you weren't entitled to because you didn't comply with the payment conditions, or you submitted that payment in violation of these fraud and abuse laws, you've got an affirmative obligation to report and repay that money. If you don't, it'll turn into a False Claims Act case. We recently had the first case come down from the Supreme Court talking about this reversed False Claims Act liability in the Escobar matter, and the Supreme Court upheld it. So yes, even if you weren't guilty when you submitted that claim, you didn't knowingly submit it in a false manner. If you subsequently learn about it, it converts into a False Claims Act case, and therefore you can be liable for False Claims Act penalties. What are the penalties? Well, at the minimum, it's repayment plus interest, but you're also going to have to pay civil monetary penalties of anywhere from $5,500 to $11,000 per claim. That's not per scheme or per plan that you had. That's per claim. So every time you submitted a claim, you can get hit up with these additional penalties. You can get hit up with treble damages and also be excluded from Medicare and Medicaid. In addition, under the False Claims Act, the False Claims Act deputizes private individuals to essentially act as bounty hunters. They are allowed to bring these key TAM suits. Under these key TAM suits, private entities may sue the hospital or other healthcare provider under the False Claims Act on behalf of the government. If they win, the key TAM relator can recover a percentage of that fine or penalty. The government may or may not intervene in those situations. This is the way a lot of the False Claims Act cases are coming to the government right now. A case in point is the Drakeford v. Twomey case. In this Twomey case, you had a key TAM relator, a physician, who challenged certain part-time employment contracts that were entered into by the hospital. They went to trial. The jury ultimately concluded that those part-time employment contracts violated Stark. The penalties under Stark amounted to $39 million, but the government also said, hey, these are false claims. Because they are False Claims Act violations also, because the claims were submitted in violation of Stark, they turned into False Claims Act. They got hit up with an additional treble damages. That increased the penalties to $117 million. And then, because they submitted 21,000 claims to the government in violation of Stark, they got hit up with the penalties of $5,500 per claim. That was an additional $119 million. Total ticket for that violation was $237 million. Now, it ultimately settled for $72.4 million, but I'm assuming that's a big hit to any of your bottom lines. The relator out of that particular case, the person who filed that key TAM suit, was supposed to receive $18 million. Bottom line is you got to be concerned about these situations. Now, I presume that none of you would knowingly go out and intentionally submit a false claim to the government, but sometimes these claims can be submitted in an improper manner, even if you didn't know that they were false. It may be that the claims for services, you submitted claims for services that were not provided or different than claimed. Maybe you failed to comply with the quality of care. When you're submitting that claim to the government, you are impliedly certifying that the services were medically necessary and that they complied with the standard of care, they weren't worthless. If you submit claims that the government thinks are essentially worthless care, then they have claimed that that is a false claim. It could be failure to comply with the conditions of participation, or for purposes today, failure to comply with the fraud and abuse laws. When you're submitting those claims to the government, you are impliedly claiming that that these claims comply with the applicable laws and regulations, and if you are submitting those in violation of the laws or regulations, then that is a false claim. It could be, in the wake of the Affordable Care Act, a failure to timely report and repay. In fact, we recently had the first case that came down in August where an entity got hit up with False Claims Act penalties because they failed to timely report and repay repayments that they had received. All right, that's the False Claims Act. Let's talk about the Anti-Kickback Statute. The Anti-Kickback Statute says that you cannot knowingly and willfully offer, pay, solicit, or receive remuneration to induce referrals for items or services covered by a government program unless that transaction fits within a regulatory safe harbor. Let's talk about a couple of those points. First, note that you cannot knowingly and willfully offer. That means that you have to have improper intent. You have to intend to make that inducement, but that does not mean that you intend to violate the law. You don't have to intend to violate the law. You just have to intend to engage in the conduct. Improper intent or ignorance of the law is no excuse. In addition, in applying that intent standard, the government has adopted what's called the one-purpose test. That means the Anti-Kickback Statute applies and prohibits the referrals if one purpose of the remuneration is to induce referrals, even if you've got 99 legitimate reasons for doing it. If one purpose is to induce improper referrals, then that's a violation of the Anti-Kickback Statute unless you can structure the deal to fit within a regulatory safe harbor. Now, the Anti-Kickback Statute applies to only items or services that are covered by federal health care programs. So one might say, okay, well, we are just going to carve out this particular inducement program. We are only going to pay inducements for non-federal health care program beneficiaries. For private pay beneficiaries, we will still continue to offer the inducements. The government has said, well, be careful about that. Those carved-out programs may not work because if you're paying that to induce referrals for non-federal program business, we think that you may also be getting the referrals for federal program business, and therefore part of the reason for making that inducement is to get the federal program business, and therefore you may not be safe simply by carving out those federal programs. Now, what are the penalties if you violate the Anti-Kickback Statute? Hey, this is a criminal penalty. You go to jail for this one, folks. You can get it in prison for 5 years, a $25,000 criminal fine, a $50,000 administrative penalty, treble damages, and automatic exclusion from Medicare or Medicaid. In the wake of the Affordable Care Act, also the anti-kickback violation is not only a criminal violation, but it's also an automatic violation of the False Claims Act. What does that mean? Well, that means you can get hit up with all those penalties under the False Claims Act in addition to the penalties under the Anti-Kickback Statute. In addition, because the False Claims Act is a civil penalty, a civil statute, the standard of proof for establishing a violation is lower. It's easier for the government to establish a violation of the False Claims Act than the Anti-Kickback Statute. So they may, instead of going after you for an anti-kickback violation, simply use the fundamental claims to go after you for a civil action. In addition, because it's now a violation of the False Claims Act, you can get hit up for key TAM penalties. The government has indicated if you have an anti-kickback violation, you go to the government with a mea culpa and you self-report. They have said that the minimum amount that they will settle for, that they will accept as part of the OIG self-disclosure protocol for an anti-kickback violation is $50,000. The net effect of this is anytime you want to give or receive anything to induce or reward referrals or do any deal with a referral source, whether that's a vendor, whether that's another provider, whether that is a patient, you've got to be concerned about the anti-kickback statute. Case in point, Olympus recently had to pay $646 million for allegedly making illegal payments to doctors and hospitals in the United States and other places. Now, the anti-kickback statute is incredibly broad. It applies to giving, offering, receiving any form of remuneration to induce or reward referral for a federal program business. Remuneration is anything of value. It could be money. It could be free or discounted items or services like offering perks or gifts or free space or discounted space or equipment or meals or insurance or trips or CME or anything of value to a potential referral source. It could be overpayments or underpayments. You are overpaying this particular provider to provide services because you really want to get their referrals. The government could say, hey, that overpayment is remuneration, would trigger the anti-kickback statute. It could be payments for items or services that are not provided, or payments for items and services that are not necessary. You're going to pay for this particular referring provider for certain services. You really don't need the services, but this is a way to funnel money to them so that you can get their referrals. Hey, guess what? That is likely a violation of the anti-kickback statute. It could apply to professional courtesies that you might offer to referral sources, waivers or copays of deductibles. If you're offering to waive copays or deductibles to your patients in order to induce their services, them to get services, then that could be a violation. Business opportunities that are not commercially reasonable, anything else of value. If you're doing any kind of a deal with a potential referral source, which could be patients, which could be other providers, you've got to be concerned about the anti-kickback statute. Unless you can structure the deal to fit within a regulatory safe harbor. Because the anti-kickback statute is so broad, the government has created certain regulatory safe harbors that if you fit within this safe harbor, you are not liable. But you got to satisfy the requirements of the safe harbor. Now, because the anti-kickback statute is an intent-based statute, it is not essential that you fit within the safe harbor. But if you don't fit within the safe harbor, the test is going to be, is one purpose of doing this deal to induce referrals? And that's a hard standard to defend against. So you really want to try to structure your deals to fit within these anti-kickback safe harbors. If you can't satisfy all the requirements, the closer you can come to satisfying them, the better off you are, but ultimately the test would still be that one purpose test. Some of those safe harbors that exist out there, there's safe harbors for bona fide employment arrangements, for personal services contracts, independent contractor agreements, leases for space or equipment, investments in a group practice, investments in ASCs, sale of practice, certain recruitment arrangements, and so forth. If you have a potential transaction, you're going to want to likely crack the regulations and make sure that you can structure your deal to fit within one of these regulatory safe harbors. In December, on December 7th, the government actually came out with a new anti-kickback safe harbor that applies to transportation programs. I recently published a client alert on that. If you want to do a transportation program now, you can look at that client alert and get the details you need in order to structure that to comply with the anti-kickback safe harbor. Now, some people say, well, it's not a big deal, it's just a little gift, it's just a little inducement. Will that protect you? No, there is no de minimis safe harbor. But the government has suggested something to the effect that they reserve the right to go after anybody for any types of these inducements that are more than a nominal payment. They don't tell you what nominal means. Presumably, if it really is something very nominal, you happen to give a pen to somebody, probably the government's got better things to do, but there generally is no de minimis or necessarily a nominal safe harbor. Likewise, there is no fair market safe harbor, I've heard some clients tell me, well, as long as we pay fair market value for it, then we're safe. Yeah, you're probably safer, but it doesn't mean you're absolutely safe. The government specifically said, hey, if it's not a legitimate deal, if you are doing this deal, you don't have a legitimate reason for it, even if you're paying fair market value for it, we still reserve the right to come after you. If you're doing a deal you can't fit within a safe harbor, you'll want to look at other factors that may go into it, into the government's evaluation of whether or not this particular transaction poses a risk of federal program abuse. If you want, you can seek an advisory opinion. You can go to the OIG and ask them to, these are the facts, and ask them to tell you whether or not they would go after you if you enter into this deal. The government will take a look at that, and they will tell you yay or nay. Now, the government posts a bunch of those advisory opinions on its website. The advisory opinion conclusions are only binding on the participants to those advisory opinions. But if you can find a favorable advisory opinion out there, chances are the government won't go after you if you structure it in the same kind of way. To access those advisory opinions, you can go to the government's website here, the OIG's website, and it's got a list of all of those. So you want to do a particular deal, it's going to be with a referral source for government program business. The first question is, okay, can we structure to fit within a safe harbor? If not, then you may want to ask yourself, is there an advisory opinion out there that gives us guidance on how we can structure this so as to minimize our potential liability? All right, that is the Anti-Kickback Statute, very broad. Related to, but separate from the Anti-Kickback Statute is the federal STARK law, the Ethics in Patient Referrals Act. There's a lot of misunderstanding concerning STARK. STARK is pretty technical, but it helps to understand the background of STARK. Back in the 1980s, government reimbursement was going down, so physicians were out there looking for other revenue streams. You saw a lot of physicians, in order to increase their revenues, they started investing in these ancillary service lines. They would open up their own labs, or they would open up their own imaging centers and things like that. Well, the government started noticing that suddenly they were getting more and more claims for imaging and labs, and they looked around and said, well, why are these growing? Why are these increasing? And they concluded, well, these physicians now have these ownership interests, so they've got this incentive to make these referrals to these other entities they own or with which they have a financial relationship. And Pete Stark said, well, we can fix that. So they came up with the STARK law. STARK says that a physician or a member of the physician's family has a financial relationship with another entity. That physician may not refer patients to that other entity for certain designated health services that are payable by Medicare, and the government interprets that to include Medicaid. And if that physician does make an improper referral, that other entity can't bill the government for those services that were improperly referred unless the arrangement is structured to fit within a regulatory safe harbor. Well, what happens if you violate it? Well, the government doesn't have to pay you for those services. In fact, you've got an affirmative obligation to report and repay that amount that you receive per improper referrals within 60 days. That's under STARK. Of course, we also have that same obligation under the False Claims Act, so if you fail to do that, you could also violate the False Claims Act. In addition, you can get hit up with civil penalties of $15,000 per claim you submitted to the government when you shouldn't have been violated because of STARK. Physicians who enter into a scheme to try to get around STARK, they can get hit up with a $100,000 penalty. STARK violations are almost always going to constitute anti-kickback violations also, and they will almost certainly violate the False Claims Act, so you could usually get hit up with those types of penalties too. Again, case in point, that Tuami case, $237 million. The False Claims Act damages were what's really made the penalties get up to that point. Bottom line here is any financial relationship or item of value between a physician or a member of the physician's family and an entity providing designated health services, you must look at that relationship and make sure that it is structured to fit within a regulatory safe harbor. Now, important point, STARK doesn't prohibit the financial relationships with the physician. It just says, physician, if you have that financial relationship, you can't make referrals for these designated health services unless you've structured that transaction to fit within the regulatory safe harbors. And entity, if you did get an improper referral, you can't bill the government for those services. Now, the time period that you can't bill the government is called the period of disallowance. That begins when the financial relationship fails to satisfy one of the safe harbors, and it ends not when you go back and correct it, but when you go back and correct it, and if there are amounts that are overpaid or underpaid, those have to be repaid. Prospective compliance alone does not cure the problem. You've got to go back and cure it retroactively. And if you made payments, if you submitted claims improperly, you've got an affirmative obligation to report and repay. If you don't, that could be a Stark violation as well as a False Claims Act violation. Talk more about some of what it applies to. Again, Stark only applies to referrals by a physician to entities with which the physician or their family member has a financial relationship. Anti-kickback statute, it applies to referrals from anybody. Could be other physicians, other mid-level providers, other vendors, doesn't matter, it applies to anybody. Stark only applies to referrals by a physician. Physicians are MDs, DOs, oral surgeons, dentists, podiatrists, optometrists, and chiropractors. Stark also applies if the physician or their family member has a financial relationship with the provider of designated health services. So you also have to not only be worried about your financial relationships with these physicians, but also the physician's family members. Stark applies if there are referrals and that physician or family member has a financial relationship with the provider of designated health services. That financial relationship could be an ownership interest, where the physician or their family member has a direct or indirect ownership interest in the entity. That could be an equity interest, partnership, investment, joint venture, or an indirect ownership relationship. It could also be a compensation relationship. Now, compensation, again, is anything of value, kind of like the anti-kickback statute. Any remuneration, anything of value could create a compensation relationship between the physician or their family member and the provider of designated health services. It could be a contract for services. It could be offering the physician or their family member free or discounted space items or services, maybe a professional courtesy policy. It could be subsidies or support you may want to offer to the physician, the referring physician. It could be paying the physician more or less than fair market value. It could be a loan. It could be anything of value, any gifts, perks, anything of value that you are providing to a referring physician likely triggers Stark. Now, Stark, as I mentioned, only applies to, it doesn't prohibit a financial relationship, it only applies to, it only prohibits the physician from making referrals for certain designated health services. Well, what are referrals? Referrals are any time that physician is ordering or asking somebody else to do something. Referrals do not apply to service the physician personally performs. The physician can always personally perform the services, but it would apply to services the physician has anybody else perform, including incident to services, services by the physician's employee, ordering tests, anything like that that anybody else performs, that would be referrals. Now, Stark's definition of referrals does create some exceptions for services that are performed by radiologists and pathologists because they typically don't refer business. So if you're dealing with radiologists or pathologists, you may have some additional leeway, but for most physicians, it applies to any time that physician is ordering or doing a plan of care, asking somebody else to provide some kind of service. Now, the anti-kickback statute, it applies to any items or services that are covered by Medicare or Medicaid. The Stark is a little bit more restrictive. It only applies to certain types of designated health care services, certain designated health care services that are payable in whole or part by Medicare or Medicaid. That's inpatient or outpatient hospital services, outpatient prescription drugs, clinical labs, physical, occupational, or speech therapy, home health services, radiology and certain imaging services, and so forth. The government has published on its website, the Stark website, it has a list of CPT codes that are affected by Stark. Now, that list is not comprehensive, but if you want to know whether a certain service is covered by Stark, is a designated health service, it helps to go look at that CPT code list. But just remember that list is not exhaustive. If your particular CPT code appears in the list, you know it's covered by STARK, but if it doesn't appear in the list, doesn't necessarily mean that it's not covered by STARK. You have to look at the definitions. Now remember the anti-kickback statute, it's an intent-based statute. It's that one-purpose test. STARK is what we call a strict liability statute. It doesn't matter what your intent was. It doesn't matter whether you knew or didn't know that you were violating the law, knew or didn't know what you were doing. It is a strict liability. You either comply or you don't comply. There is no good faith compliance. To comply with STARK, the transaction must either fall outside the statute, meaning there's no financial relationship or no referral, or you've structured the deal to fit within regulatory safe harbor. There is a limited exception for that. If you are the provider for designated health services, you received a referral, you had no reason to know that that referral came from a provider, the physician with whom you had a financial relationship, then in that situation, you're not going to be held accountable for submitting that claim if you did not know and should not have known. That's a pretty rare case, though. Now, because of STARK is so broad and so draconian, the government has come up with safe harbors, like the anti-kickback statute. STARK contains numerous safe harbors. Some are applicable to both ownership and investment and compensation arrangements. Some are applicable only to ownership or investment arrangements. Some are applicable only to compensation arrangements. There is no liability under STARK if you structure the deal to satisfy all the requirements, but you got to satisfy all the requirements in that safe harbor. You only need one applicable safe harbor for each of your transactions. You don't have to satisfy all of them. You just need one applicable safe harbor for each transaction. But be careful, because sometimes your transaction involves multiple financial relationships, and you need to make sure that each of those financial relationships fit within one of the regulatory safe harbors. Some of the safe harbors that would apply to both ownership relationships and compensation arrangements. There are safe harbors for physician services that are rendered by another physician in the same group practice, or in-office ancillary services that are provided through a group practice. Those are the ones that are most commonly used by group practices. But in order to satisfy or qualify for those STARK exceptions, your group has to satisfy certain criteria. It has to meet the definition of a group practice under STARK. And that means that there's a bunch of things that have to be done concerning the compensation arrangement, the way that it's governed, things like that. So if you're going to rely on these group practice exceptions, make sure your group satisfies the requirements of being a group practice under STARK. There are other exceptions that apply only to ownership or investment interests. If you, for example, are a provider and you provide services in a rural area, you have a lot more flexibility in that situation. You can refer business to entities that you own in a rural area. The theory there is, hey, if we're in a rural area, sometimes the only way to get these services into that area is to allow physicians to invest or open those services, and therefore we don't want to prohibit physicians from making those referrals, because that would preclude these services being open in that particular area. So rural providers have a lot more flexibility. There's exceptions for the whole hospital. If you have an ownership interest in the hospital, this allows you to make referrals to the hospital, but the government placed some caps on that recently. Most of the time you're going to be dealing with exceptions for compensation arrangements, where you don't have an ownership relationship, but you have a compensation relationship with a referring practitioner. There's exceptions that apply to bona fide employment contracts, personal services contracts, space or equipment rentals, timeshare arrangements, physician recruitment, mid-level recruitment, that's a new one that came in last year, physician retention, fair market value, non-monetary compensation up to $300. That's actually been adjusted. I think it's up to about $375 now. Medical staff incidental benefits, compliance training, community-wide health information systems, and so forth. The key with all of those is that you need to make sure that if you've got that financial relationship with a referring physician, and that physician is going to refer designated health services, that you open up the regulations and you make sure you've structured that deal to fit within one of these regulatory safe harbors. So here's the analysis for when it comes to STARK. You have to ask yourself, is there a financial relationship between the designated health service provider, like a hospital or a lab, and the physician or their family member. If there is a financial relationship, remember that could be direct or an indirect relationship, an ownership or investment interest, a compensation arrangement. If there is that relationship, does that physician make or has she made referrals to the entity that are payable by Medicare? Again, you can have the relationship so long as there's no referrals. That's not a Stark problem. It's only a Stark problem if you have that financial relationship and that physician is going to make referrals for certain designated health services. If they are, then you've got to ask yourself, does a safe harbor apply? If it does, you should be fine. If it doesn't, you got to be nervous. What are some of the common Stark problems that are out there? Well, these are some of the more common ones. Maybe you have no written contract for services. Employed physicians, you don't need a written contract, although it's usually a good idea. For independent contractor physicians, you need a written agreement, and that written agreement generally needs to be current, although they recently amended Stark so that you can have some holdover situations. Now, on that written contract for services, also the government recently revised Stark so that it makes it a little bit easier to establish that the contract terms in writing. You don't necessarily need a formal contract. You just need to have in writing the terms that are necessary to confirm the nature of that agreement. Sometimes you will provide free space or equipment to physicians without an appropriate lease. Maybe you're paying compensation that is more than fair market value. Either it was more than fair market value when you started, or the terms of the agreement have changed over time. You're still paying this physician X dollars, even though that physician is not still providing the services. Or maybe it's a situation that physician's providing more services and you're not paying them enough. If the compensation structure takes into account referrals, maybe you're paying a percentage of revenues that are generated by others, or allowing the physician to participate in some kind of profit sharing or gain sharing arrangement. In those situations, if that compensation varies with the volume of value referrals, it's probably not going to meet an applicable Stark safe harbor. Remember, there's an exception for personally performed services. Stark doesn't prohibit the physician from personally performing the services, but if they're making any referrals for services that are performed by others, then that would apply. If the compensation changes within 1 year for independent contractor physicians, generally those compensation terms have to be set in place for 1 year. If you change those within those 1 year periods, you're going to fall without the safe harbor. Now, that doesn't apply to employed physicians, but it does apply to any physicians with whom you have an independent contractor relationship. Maybe you're providing free or discounted items, services, or subsidies like professional courtesies, incidental staff benefits, practice subsidies, support staff, those types of things. If you are, you're going to want to look and see if you can structure the deal to fit within one of the applicable safe harbors. If not, you probably have a Stark problem. Just like the anti-kickback statute, the government does publish advisory opinions concerning Stark. They post them on the website. You may want to take a look at those if you've got a transaction with which I think you may have some concerns. All right, let's talk about the fourth law that you have to be concerned about. That is the Civil Monetary Penalties Law. On just a few days ago, or actually on December 7th of 2016, the government issued a couple of regulations that revised the Civil Monetary Penalties Law. They didn't do a lot of substantive changes to the standards that are applicable, although some of them changed. Most of what they did was simply restructure the Civil Monetary Penalties Law to make it easier to identify what the misconduct is, what the associated penalty is. So they restructured the CMP regulations to make it more user-friendly, including they included standards for determining the amount of penalties, and they grouped the types of penalties into subparts. The Civil Monetary Penalties Law covers a broad range of conduct. It prohibits certain types of specified conduct, such as submitting false or fraudulent claims or misrepresenting facts. It includes violating the Anti-kickback Statute or Stark Law, violating EMTALA, failing to report and repay an overpayment, failing to grant timely access to the government. If they show up and want to do an investigation, you generally got to provide them access. If you refuse, you can get hit up with civil monetary penalties. Misusing names like Health and Human Services, CMS, if it hasn't been approved, if it's improperly suggesting that you have their approval when you really don't. failing to report adverse action against providers. But these are the ones that I really want to talk about. The Civil Monetary Penalties Law prohibits you from offering inducements to program beneficiaries, i.e. Medicare or Medicaid patients. It prohibits you offering inducements to physicians to limit medically necessary services, and it prohibits you from submitting claims for services ordered by or contracted with an excluded entity. Those are the ones that seem to come up the most. Let's talk about each one of those. First, what are the penalties for a civil monetary penalties law violation? Well, the penalties depend upon the type of conduct involved. It's anywhere from $2,000 to $100,000 in fines. You can get hit up with trouble damages, denial of payment. You'll have to do repayments, and you can be excluded from federal government programs. Just like Stark and Anti-kickback statute, if you've got a CMP violation, you probably also got a False Claims Act violation and may have an Anti-kickback or Stark law violation. Let's talk about those main ones that seem to come up a lot in the civil monetary penalties law. The first one is you cannot offer or transfer remuneration to Medicare or state program beneficiaries if you know or should know that the remuneration is likely to influence the beneficiaries to order or receive items or services payable by federal or state programs from a particular provider. So you can't go out and offer your Medicare patients, hey, come to us and we will give you freebies. What's the penalty? $10,000 for each item or service, treble damages, repayment of the amounts repaid, and possible exclusion from Medicare or Medicaid. That if you're offering those incentives to your Medicare beneficiaries, then chances are you've also got an anti-kickback violation. Now, it says that you can't offer remuneration. What do they mean by remuneration? Well, again, it's anything in value, including specifically but not limited to items or services for free or less than fair market value, unless you satisfy certain conditions, or waiver of co-pays or deductibles, unless you satisfy certain conditions. If you're engaging in those practices or offering any other items or services of value, anything of value, then you potentially have a CMP violation if you're doing it in order to induce them to come to you to receive services that are payable by Medicare. Now, remuneration is defined to exclude certain things. These are kind of like your safe harbors. Remuneration does not include items or services if you have documented financial need and you can satisfy certain other conditions. So you can provide free or discounted items or services if you can show that the patient has documented financial need and you can satisfy certain conditions. In addition, remuneration does not include, you can waive or discount co-pays if it's not offered as part of an advertisement or solicitation. So you're not out there advertising on your website or on the radio, hey, come to us and we will do insurance-only billing. That does not work. In addition, your waiving of co-pays and deductibles can't be routine, and it can only be made after a good faith effort that the patient is in to determine that the patient's in financial need, or after failed collection efforts. If the patient is in financial need or you've tried to collect the money, then you can go ahead and waive the co-pays or deductibles so long as you don't advertise that as a practice, you don't use it as a marketing gimmick, and you don't do it on a routine basis. Also, remuneration doesn't apply. You don't have to worry about this civil monetary penalties, prohibition against inducements to beneficiaries if you can structure your deal to fit within a regulatory safe harbor under the Anti-kickback statute. You're okay as long as you can offer certain incentives to promote the delivery of preventative care if you can satisfy certain criteria. You can offer certain items or services that improve the beneficiary's ability to obtain items or services payable by Medicare or Medicaid so long as it poses a low risk of harm. The government hasn't given us a whole lot of guidance on what that means. Certain retailers can offer coupons if certain other conditions are satisfied. The bottom line is, if you want to do some kind of a marketing scheme to offer freebies to your Medicare, Medicaid population or other recipients of federal health care dollars, you want to offer those inducements, you've got to be concerned about the civil monetary penalties law as well as the anti-kickback statute. Make sure that you take a look at it and see if you can structure your arrangement to fit within one of those regulatory exceptions to remuneration. Now, in addition to those, the OIG has approved the following practices in opinions or comments, even though they don't appear in the regulations themselves. The OIG said, hey, we won't go after you if you are offering items of low value, and they define items of low value. They actually just increased the amount on December 7, 2016. They increased the amount from $10 to $15,000 per item, or up to $75,000 per patient per year. So if you want to offer your patients some gift or thank you that is up to $15 per gift, and you don't give any particular patient more gifts totaling a total of $75 per patient per year, then you should be okay, at least for purposes of the civil monetary penalties law. There is no similar statement for the anti-kickback statute, but if you're complying with the civil monetary penalties law, you're probably going to be okay under the anti-kickback statute. The government has also approved free screenings. Maybe you want to go out there and offer some type of free service or free screening program in the public. They said you could do that so long as you're not conditioning or tying that free service on other referrals. So it's not like, okay, we'll provide you this free service, but only if you purchase this other service. Or we will provide you this free service, and by the way, I'm going to usher you in, if your tests come back positive, we're going to usher you into into our clinic to receive these additional services that are payable by Medicare. You can't tie those services in. The government has issued an advisory opinion. If you do those free services or free screening programs, you ought to take a look at that advisory opinion and make sure that you've structured it appropriately. The government has also approved free transportation programs. As I mentioned, the government just came out with that new anti-kickback safe harbor program for free transportation programs, where you may want to send out a bus or help your provide some kind of support for your patients in order to get to you. If you want to engage in those transportation programs, open up the anti-kickback safe harbor and take a look at those requirements for those transportation programs. All right. That was a discussion of the inducements to beneficiaries. The civil monetary penalties law also prohibits hospitals or critical access hospitals from knowingly making a payment directly or indirectly to a physician as an inducement to reduce or limit medically necessary services that are provided by Medicare and Medicaid beneficiaries. The background of this is, remember back in the 1980s, 1990s, when we switched to the prospective payment system and the DRG system, so that hospitals now are not paid necessarily based on a fee for service, but they were based on this diagnosis. And so it created this, because the hospital's recovery was capped for this particular episode of care, it created an incentive for hospitals to reduce the care that was provided to a particular patient. The government was concerned about hospitals going to the physician and saying, hey, if you help us reduce the cost of this care by not ordering certain services or not doing certain things for the patient, then we will split those cost savings with you. We will give you this if you help us reduce those costs. The government was concerned about those situations, hence they came up with this civil monetary penalties law that prohibits offering those types of inducements. Now, traditionally, those have precluded gain-sharing arrangements where the hospital would go to the physician and say, hey, help us save costs. Those typically violated this provision. Now, what happens if you violate it? Well, there are penalties of $2,000 for each individual with respect to whom the payment was made, so per patient. In addition, there's penalties. You could get hit up with penalties under the anti-kickback statute or the the Stark law that wouldn't apply. So you had to be concerned about that. Now, you're thinking, scratching your head, saying, well, wait about it. What about the Medicare Shared Savings Program? What about the Affordable Care Act? Isn't that all about trying to reduce these savings? Isn't that about gain-sharing programs? You're right. And so as part of MACRA, the government went in there and revised the statute. It used to be that you couldn't provide any of these inducements to induce or reduce services, induce the reduction of services. In MACRA, they revised that, so now this statute only prohibits offering these inducements to limit medically necessary services. So if you could enter gain-sharing arrangements with a physician, so long as it doesn't apply to medically necessary services. So if you're reducing medically unnecessary services, then presumably you could enter into those agreements. this recent change in NACRA makes possible certain gain sharing and other arrangements that might not have been possible before. Now, the OIG has periodically approved gain sharing arrangements with physicians despite the civil monetary penalties law. They've issued advisory opinions. Usually those gain sharing arrangements that have been approved have some certain common elements. For example, the proposed plan does not adversely affect patient care. Quality is evaluated by a third party. There's a low risk that the incentive will lead physicians to provide medically inappropriate care, and the payments are limited in duration and the amount. If you want to enter into such an arrangement, you may want to call out those advisory opinions, take a look at it, and make sure that you can structure it appropriately. Well, what about Stark and the Anti-Kickback Statute? Just because you can do it under the Civil Monetary Penalties Law, you still may have liability under Stark and the Anti-Kickback Statute. Those are separate statutes out there. If you're doing this type of a gain sharing arrangement with a physician, that's going to create a financial relationship for purposes of Stark. The government had proposed, or they have issued rules waiving CMPLs in the case of Stark for certain ACOs, accountable care organizations, but it's limited to those accountable care organizations under the Medicare Shared Savings Program. The bottom line is, if you want to do these gain sharing arrangements, you need to not only look at it for compliance with the Civil Monetary Penalties Law, but also in compliance with Stark. All right, the last one that I wanted to talk about briefly here is excluded entities. Once an entity is excluded from participating in the Medicare or Medicaid program, it's kind of like the death knell. They can't participate in those programs. The government says that if you are excluded, you cannot submit a claim for an item or services that is ordered or furnished by an excluded person. So if you're excluded, you can't submit the claim. If you're employing an excluded person, you can't submit a claim for items or services that are payable by the federal health care program if it was ordered by that or furnished by an excluded person. In addition, you cannot even hire or contract with an excluded entity or arrange for an excluded entity to provide items or services payable by federal health care programs unless you've taken certain steps to kind of cut off or segregate that person's compensation from any federal program business. It's pretty hard to do. Under some of the recent guidance, they've given us some clarification on how that's done, but that's difficult to do. The bottom line is, you need to be careful about contracting with or hiring persons who are excluded from federal health care programs. What are the penalties if you do that? Well, $10,000 per item or service that you submit a claim to the government for, 3 times the amount claimed. You'll have to repay any amounts that you receive from the government, and you can be excluded from Medicare and Medicaid. Now, Medicare and Medicaid, or the federal program, is not going to pay the claim if the person knew or should have known of the exclusion. So it only applies if you knew or should have known of the exclusion. There's an exception for emergency services. We won't go into that. But it only applies if you knew or should have known of the exclusion. Well, how do you know or should have known? Well, it may be a situation where you have actual knowledge or the government has notified you of the exclusion because you submitted the claim and they came back and said, no, this person's excluded, we're not going to pay you. Or that excluded individual has been listed in the government's list of excluded individuals or entities, the LEIE. The government has this list that they publish on about a monthly basis. They expect you to go in there and check that periodically to make sure that you're not contracting with or granting privileges to any entities that are on that particular list. How often do you need to do that? Well, before you hire or contract with an entity, you know, your employees, your contracted physicians, you're going to want to check that list. In addition, even after you hire them or contract with them, you're going to want to check that LEIE periodically thereafter to make sure that they don't appear. How often do you need to do that? Well, we haven't got a clear black and white rule, but really the only way to be safe is to check that on a monthly basis. There are ways that you can set that up so that you can automatically cross-check it against your list of employees or your list of physicians with or other healthcare providers with privileges at your particular facility, but that's the safest thing to do. You should condition your contracts and medical staff membership on non-exclusion so that if a person is excluded, it gives you the right to automatically terminate your contract or relationship with them. If you do get notice that a person is excluded, you need to respond promptly to make sure that you're not submitting any claims. If you have submitted claims, you need to go back and determine, okay, how long have we known about this, or did we know about it? When should we have known about it? Because you may have a report and repayment obligation. All right. With the civil monetary penalties law, again, just like anti-kickback and Stark, the government does post advisory opinions. If you have a question, you can submit an advisory opinion, or more often, if you want to see whether a particular practice violates certain civil monetary penalties law, you can go look at that advisory opinion list, see if you can find a similar one. All right, those are the federal laws that I wanted to talk about. Real briefly, don't forget about your state laws. We tend to focus on the federal laws, but remember, each state may have its own laws. All states have their own False Claims Act provisions that you need to be familiar with. So even though you don't owe money back to the feds, you may owe money back to your particular state under your particular state False Claims Act. Almost all states have some kind of anti-kickback statute. Some states have their own mini Stark laws. Almost all states have, as part of the Medical Practices Act, fee-splitting statutes or payments for referrals or things like that may apply. You need to be familiar with. They may have healthcare fraud statutes that prohibit submitting false claims to insurance companies, all of those. Just make sure you're aware of those fraud and abuse laws that may apply in your particular state. Remember, when you're looking at those state laws may be broader than the federal laws. Usually the federal laws, as we've talked about, only apply to items or claims that are submitted for programs that are payable by federal program dollars, Medicare, Medicaid, those types of things. They may not apply to private pay. In contrast, however, your state laws may apply to private pay. You need to be familiar with your state laws. In addition to the state laws, you still need to be concerned about your payer contracts. Even if you're not violating a law, you may be violating your payer contracts by engaging in certain types of activities. Well, you may be a little bit nervous about all of this stuff. How do you address this? Well, the best way to address it is having an effective compliance plan. The best defense is a good offense. Why do you want an effective compliance plan? Well, the ACA is going to require that if the ACA is around. We don't know whether the ACA is going to be around. The Affordable Care Act does require entities to complete a compliance plan, although we don't have the requirements specifically for most providers yet. Even if the ACA goes away, however, why do you want a compliance plan? Well, because it helps you. It may actually facilitate compliance and avoid repayments, obviously. It may help you avoid fraud charges, even if there is an improper claim that is submitted. If you had an effective compliance plan, you may be able to show that, look, it wasn't done intentionally. It wasn't fraudulent. We may still have a repayment obligation, but you may not be subject to fraud claims and may not go to jail. It may help you mitigate the penalties. If the government comes in there and looks and is assessing penalties, whether you had an effective compliance plan is one of the factors that they will look at. It may actually improve your performance. A lot of times I'm involved a lot with potential repayments. Usually when we've gone in there and done audits, we conclude that not only were there amounts that they received that were overpayments, there were usually underpayments, and quite often those underpayments exceed the amount of the overpayments. If you have an effective compliance plan, it may help you ensure that you're getting all the money you deserve, not just that you avoid getting money that you don't. In short, an effective compliance plan is preventative medicine. The government has published guidance concerning compliance plans for different industry segments, such as hospitals, home health providers, small physician groups, and the like. That's available on the government website here. It's important to note that OIG compliance program guidance is not mandatory yet. You're not required to implement that. Also, it's not a compliance program itself. It's not like you can print this off and say, here's the compliance program. What it does do is give you guidance concerning how to structure your own compliance plan. It gives you 7 elements, and if you include those 7 elements in your compliance plan, then the government will take it easier on you if they come and look at you. Those 7 elements include those elements that are listed up there on the screen. So you may want to go back and look at your compliance plan and make sure that it has those 7 elements. All right, in my final minute, I'm just going to touch base briefly about some action items. Well, we've talked a lot about this stuff today. You may want to go back there and review your internal policies and practices to make sure that you are compliant with these federal regulations. Among other things, you're going to want to identify remuneration that you're giving or receiving to or from referral sources. That could be providers, facilities, vendors, government program patients, and the like. It could include contracts that you have with those other entities, your own internal group compensation structures, your leases, subsidies or loans, joint ventures, partnerships, free or discounted items or services, anything of value. If you've got some kind of financial relationship with these potential referral sources, make sure you identify those. Then you're going to want to look at those and make sure that those relationships have been structured to fit within one of the regulatory safe harbors or otherwise confirm that the regulations don't apply. Generally, you want to make sure that there is, if you do not fit within a safe harbor, that there's no intent to induce referrals. If there is an intent to induce referrals, then you're going to want to make sure that it's structured to fit within those regulatory safe harbors. That means generally that you should have written contracts that are current and signed by the parties, that you are complying with the terms of the contract and monitoring ongoing compliance. So suddenly, you know, a year down the road, you're paying this physician even though that physician is not doing the services. Make sure you're paying fair market value, that the compensation is not based on the volume or value of referrals, and that the arrangement is commercially reasonable and serves a legitimate business purpose. It's not just a sham as a way to funnel money to a potential referral source. You should implement a method to track and monitor your relationships with referral sources for compliance. Maybe having a central repository of all your contracts, making sure that there's a process whereby you go through a review from your compliance officer or somebody who knows about these compliance rules before you engage in any of these services. Particularly, you have to be careful about your marketing program. Your marketing program may be out there doing things that they have no idea violates the federal rules. Shoot, we do these things all the time in other industry segments, but what you do in other industry segments may violate the law in the healthcare industry. Ensure your compliance policies address fraud and abuse laws. Train key personnel concerning compliance, the things that we talked about today. In fact, if you wanted to, you could use this recording from this program to provide training. That would include your administration, obviously your compliance officers, human resources, because they may be affected, physician relations and medical staff officers, marketing and public relations, your governing board members, your purchasing department, accounts payable. Make sure that you document the training that you provided to them. If you think you have a problem, don't do this because things don't get better. Remember, you now have an affirmative obligation to report and repay. If you think there is a problem, suspend your payments or your claims to Medicare or Medicaid until you get it resolved. It's one thing to submit a claim when you didn't know that there was a problem. It's another thing to continue to submit those claims after you know that there's a problem. If you know they're non-compliant and you're submitting the claim, hey, that's a false claim. You can go to jail for that type of stuff. That could be fraud in addition to False Claims Act penalties. Investigate the problem per your compliance plan. You might want to consider involving an attorney to maintain the privilege to the extent you can, the attorney-client privilege. Implement appropriate corrective action, but remember that prospective compliance isn't necessarily enough. Just because you correct it going forward does not cure the problem if you've received improper payments in the past. You may have an affirmative obligation to report and repay. If the repayment is due, report and repay per the applicable law. The government has self-disclosure programs that we are going to talk about next week for those of you who are interested. For additional resources, the government has a lot of fraud and abuse resources on its website that are extremely helpful. You can go to this website, you can get videos, guidance, things like that. Also on our website, we've got a lot of information out there, including articles, guides we've written, and webinars concerning these and other topics. As far as upcoming webinars, next week we're going to be talking about what you do if you have violated some of these laws we talked about today, whether you're reporting and repaying requirements, how do you go about doing the self-disclosures. We'll talk about that next Thursday. On January 26th, we've got a webinar on the new long-term care facility rules that issued at the end of last year. In February is our HIPAA month in recognition of the deadline for reporting improper HIPAA disclosures during February. So we will be talking about different aspects of HIPAA in February. If you would like to participate in any of those webinars, shoot me an email, or you can sign up for them by going to our website. And I think that is it. If you have any questions about the things we've talked about today, feel free to shoot me a quick email, and I will respond offline. Just make sure that you note that the question is pursuant to this particular webinar. Thank you very much for your participation. Always nice to talk with you, and I hope this has been helpful.